When we think about what shapes America, we usually think of big things, right? Presidents, wars, major events. But there's this other, quieter force that has, honestly, had just as much of an impact: the Supreme Court. We're going to dive into some of the biggest, most pivotal decisions ever made and see how just 9 people in robes have shaped, well, everything, from the power of the government all the way down to our most personal rights. So let's get into it. So let's just jump in with this question. How on earth can a court case from 1803, we're talking about a time with horse-drawn carriages and quill pens, how can that possibly change your life today? It sounds kind of crazy, right? But the answer? Well, the answer is where the Supreme Court gets all of its incredible power. Okay, so here's the thing you gotta remember. The Supreme Court wasn't always this powerhouse. Nope. When it first started, it was kind of the runt of the litter. Seriously, it was seen as the weakest of the 3 branches of government. It had to find its voice. And when it finally did, man, it really learned how to shout. And that echo is still being heard today. And our story really kicks off with this guy, Chief Justice John Marshall. The Marshall Court, from 1801 to 1835. When he came on the scene, the court was, let's be honest, an afterthought. Nobody was really paying attention to it. But Marshall, he had big plans. He was about to take this tiny, wobbly institution and turn it into a solid pillar of American government. And the big moment, the real game changer, came in 1803 with a case called Marbury v. Madison. It was frankly a brilliant political move. Marshall used this case to establish this core idea called judicial review. And what is that? Well, it's basically the court giving itself the ultimate power to decide what the Constitution actually means. It means they can look at a law that Congress passed, that the president signed, and say, nope, that's unconstitutional. It's out. That's a huge deal. And here it is, the line that changed everything. A law repugnant to the Constitution is void. Simple words, right? But absolutely revolutionary. Marshall basically said, the Constitution is the boss, and we, the Supreme Court, are the ones who get to say what the boss means. So every single time you see a modern law being challenged today, whether it's about healthcare or voting rights or tech, you're watching that exact power in action. There's a straight line from 1803 to the news you'll watch tonight. All right, so the court has its power now. It's found its voice. So what's the first big test? Well, it was a massive question for the new country. Who's really in charge? Is it the federal government or is it the states? It was the ultimate tug of war, and the Supreme Court was about to become the referee. And that brings us to a case called McCulloch versus Maryland in 1819. This one was all about the balance of power. Here's the setup. Maryland tried to tax the national bank, and the court had to step in. Marshall's argument was super clever. He said, look, the Constitution gives Congress implied powers. These are things that aren't written down word for word, but are, necessary and proper for the government to actually do its job. And the final ruling was crystal clear. If a state law and a federal law are fighting, the federal law wins. Period. This decision basically cemented the federal government's authority, and believe it or not, it's the reason we have things like a national air force or federal food safety laws today. But, the court's history isn't all just about who has more power. It gets much, much messier. The court gets tangled up in the country's biggest, most painful moral fights. And in these next cases, well, the court didn't just solve problems. Sometimes it threw gasoline on the fire. So now we're moving into the era of the Taney Court, led by Chief Justice Roger Taney. And this is where we get to what is almost universally seen as the single worst, most damaging decision in the court's entire history. A decision that literally helped push a divided nation right over the edge. We're talking about the Dred Scott case from 1857, and this ruling was just devastating. The Taney Court didn't just say that Dred Scott wasn't free, it went so much further. It declared that no person of African descent could ever be a U.S. citizen, and because of that, they had no rights to protect. Can you imagine? Instead of calming things down, this decision was a bombshell. It enraged the North and just slammed the gas pedal on the country's path to the Civil War. So the Civil War happens, slavery is abolished. But the fight for true equality, that was far, far from over. Sure, the 14th Amendment granted citizenship, but the big fight was over what that citizenship actually meant in real life. And as the 19th century came to a close, a whole new system of oppression started to rise up to answer that question, and the answer was brutal. And then in 1896, the Supreme Court weighed in with a case of Plessy v. Ferguson. And what they did was give their official legal stamp of approval to segregation. They came up with this doctrine called separate but equal.
With those three words, the court made racial discrimination the law of the land, basically tearing up the promises of the Civil War and setting the stage for decades of injustice.
And just look at this timeline. We're not talking about a few years here. For nearly 60 years, that's a whole lifetime for some people, separate but equal was the rule. It was the legal excuse for Jim Crow laws that controlled every aspect of life in the South: schools, hospitals, buses, even water fountains. It was a long, dark, and incredibly painful chapter.
But here's the thing about the court. Just as it can create injustice, it can also tear it down. And in the middle of the 20th century, we see this huge, dramatic shift. The court starts to change its focus away from just big questions about government power and toward protecting the rights of individual people. And this was an era that was going to change America forever.
And then, the moment of truth, 1954, Brown versus the Board of Education. In a unanimous decision, everyone agreed. The court declared that separating children in public schools based on race was inherently unequal. It flat out said separate but equal has no place in education. This didn't just overturn that awful Plessy decision, it lit the fuse for the modern civil rights movement. It was a seismic shift.
And this revolution of individual rights just kept rolling. Let me tell you about a man named Clarence Earl Gideon. He was charged with a crime in Florida, but he was broke. He couldn't afford a lawyer, so he asked the judge to give him one. The judge said no, so Gideon had to defend himself. And, no surprise, he lost. But from his prison cell, he wrote an appeal to the Supreme Court, and the court heard him. They made a landmark ruling that everyone, and I mean everyone, rich or poor, has the right to a lawyer if they're accused of a serious crime.
And this protection for the accused got even stronger a few years later with Miranda v. Arizona. This case gave us those famous lines you've heard in 1,000 TV shows and movies. You have the right to remain silent. All of that comes from this case. A guy named Ernesto Miranda confessed to a crime, but his confession got thrown out because nobody told him he had the right to shut up or to get a lawyer. So now, because of this case, police have to read those rights to anyone they arrest.
Okay, this brings us much closer to our own time and into what is probably one of the most hotly debated things the court has ever done: finding rights that aren't actually written word for word in the Constitution. This idea has sparked some of the biggest, most intense arguments in our society, and those arguments are still raging today.
It all started with a case in 1965 called Griswold v. Connecticut. There was this really old law in Connecticut that actually banned contraceptives. The Supreme Court took a look at this and struck it down. And their reasoning was fascinating. They said, okay, the word privacy isn't literally in the Constitution, but if you look at a bunch of the amendments together, they create this zone of privacy around really personal decisions. This was a huge, huge step.
And that right to privacy that came out of the Griswold case, well, that became the legal foundation for what is arguably the most famous and most controversial Supreme Court decision of all time: Roe v. Wade. In 1973, the court said that this right to privacy was broad enough to protect a woman's decision about abortion. And as you know, that ruling has been at the absolute epicenter of American politics and law ever since.
So think about this journey we've just taken. From the court literally giving itself power to drawing the line between federal and state governments, from enabling segregation to then tearing it down, from protecting the rights of the accused to creating a right to privacy. The story of the Supreme Court is the story of America, which really just leaves us with one big question, right? What are the fights happening right now over things like AI or climate change, or what privacy means in a digital world, that are going to become the landmark cases of tomorrow? The ones that people will be talking about 100 years from now. Because one thing's for sure, the court's work is never, ever done.